Welcome, everybody, to the section meeting for the Administrative Law section of AALS. If we've not met before, my name is Kent Barnett of the University of Georgia School of Law, and I'm completing my term as chair of the section. We're delighted that you've joined us today for a timely discussion of the past and future of the non-delegation doctrine, co-sponsored by the Constitutional Law section. Before we begin, I wanted to briefly thank you for the privilege of serving as chair of the section and to thank our panelists today and the executive committee, our incoming chair, Katie Kovacs of Rutgers, our chair-elect, Mila Sahoni of San Diego, Jamel Sharp of Illinois, and Glenn Stachewski of Michigan State, and our immediate past chair, Jack Bierman of Boston. We also welcome our new executive committee member, Anuj Desai from Wisconsin. Please do not forget about our new Voices program, which is set to begin at 4:15 this afternoon, co-sponsored with the section on legislation and political process, and also a Zoom social meeting that Jack Bierman is going to begin hosting as soon as the new Voices program is complete. With that, I'll hand it off to Jamel to announce our Emerging Scholar Award winner. Jamel?
Hello, everyone. This is Katie Kovacs from Rutgers Law School coming at you live from Philadelphia, where bad things happen, and tweeting at Katie K Square 90. I am incoming section chair for 2021. If you are not yet a member of the section, please join the section. I promise we won't inundate you with emails, but please do join the section. Given all the events of the week, I feel like we should have renamed this panel "There's More Than One Way to Dismantle the Federal Bureaucracy." I will turn it back over to Jamel, who I believe is back with us now to announce the section award, and then we'll get started with our program. So Mike, if you can send it back over to Jamel, that would be great.
Thanks, Katie. I hope everybody can hear me now. Got the thumbs up. Okay, sorry about the technical difficulties there. As I was saying, right, as chair of the section's Emerging Scholarship Award Selection Committee, it's my honor to announce this year's winner. But before I do so, I want to make sure that I thank the section members who graciously volunteered their time to serve on the committee this year. Bernie Bell, Catherine Kim, Jeff Pojanowski, and Andy Popper. Thanks to all of you for your time and your thoughtfulness. It's a very busy time for many of us. So thank you for participating in this year's selection process. After a multi-round anonymous review, I'm pleased to announce that Joy Milligan of UC Berkeley is this year's award recipient for her excellent article, Plessy Preserved Agencies and the Effective Constitution, published last year in the Yale Law Journal. The article is timely, it was meticulously researched, and it's deeply insightful. So Joy, on behalf of the section, congratulations on authoring such an excellent piece of scholarship and on receiving this year's award, richly deserved. So with that, I'll turn it back over to Katie to proceed with our panel discussion today. Katie?
Thanks so much, Jamel, and congratulations. So let me introduce the discussants for our discussion of non-delegation doctrine very briefly, and then I'm going to remind you again very briefly of what the Supreme Court said in Gundy versus U.S. back in 2019, and turn it over to our discussants. First, we have Julian Davis Mortensen, the James G. Phillip Professor of Law at the University of Michigan, who tweets at J.D. Mortensen. Elon Verman, Associate Professor at the Sandra Day O'Connor College of Law at Arizona State, tweeting at Elon_Verman. He says Werman, but yeah, I can't get away from it. And lastly, but certainly not leastly, Jillian Metzger, the Harlan Fiske Stone Professor of Constitutional Law at Columbia University, tweeting occasionally from Jillian Metzger too. I give you the Twitter handles because there is a robust conversation about administrative law going on at Twitter that you may want to partake in. I won't introduce our discussants further. You can find their bios online. It would simply take too long to cover even their most basic accomplishments. Suffice it to say that they are all accomplished scholars and also active in litigation, so well grounded in the real world. Now, again, let me remind you briefly of Gundy versus United States, and then we'll have brief remarks by each of the three discussants, and then open the conversation. I'll be monitoring the chat, so please keep your questions coming. So 2019, Gundy versus United States was about the Sex Offender Registration and Notification Act, or SORNA, which requires sex offenders to register. It delegates authority to the Attorney General to issue regulations applying the act to convictions predating enactment of the statute. In 2012, in U.S. v. Reynolds, the Supreme Court interpreted the act to apply to convictions, to apply only to convictions after enactment until the Attorney General issued regulations applying the act to pre-act offenders. Gundy was one of these pre-act offenders who was convicted of failing to register. The Supreme Court granted cert on the question whether the delegation to the Attorney General violated the Nondelegation Doctrine, even though there was no circuit split. In fact, 11 circuits had upheld the delegation. Justice Kagan, joined by Ginsburg, Breyer, and Sotomayor, rejected Gundy's claim. They interpreted SORNA as saying that the Attorney General's role is to apply the act to pre-act offenders as soon as feasible. And that limited delegation, they believed, easily passed constitutional muster. Justice Alito concurred in the judgment because he felt that the delegation was constitutional unless the Supreme Court reconsidered the entire doctrine. Justice Gorsuch, I'm sure you'll remember, dissented, joined by Roberts and Thomas. He enunciated three guiding principles for non-delegation doctrine. First, that Congress can authorize agencies to fill up the details of a federal statute. Second, Congress can make application of a rule depend on executive fact-finding. And third, Congress can assign agencies non-legislative responsibilities that are already within the scope of the executive power. Essentially, Justice Gorsuch read SORNA as giving the Attorney General unlimited authority to apply the act to pre-act offenders or not. So essentially, Justice Gorsuch was not satisfied with Justice Kagan's feasibility standard. He thought it left too much discretion to the Attorney General because there are too many kinds of feasibility. Justice Kagan thought that it provided enough of an intelligible principle. He disagreed. And with that, I will turn it over to Julian.
Julian, let's try that again. First time on Zoom, sorry. Welcome and thank you for the invitation to be on this terrific panel. It's really a delight to have a chance to have this conversation with all of you. So thank you, Katie and Kent. I will do my very best. I will certainly stick within the 5-minute limit. And will basically, for that reason, just cover the high level sort of conceptual framework that the argument that my co-author and I, Nick Bagley, have constructed, that there simply wasn't anything remotely approximating a non-delegation doctrine at the founding. You should be seeing my screen now, I believe. Terrific. So the question is framed, of course, by the vesting clauses. The first sentence of each article, Article 1, Article 2, Article 3, vests a specific form of power in a specific branch of government: legislative powers, executive power, and judicial power. The article that, or this project, I should say, emerges actually not at all from a desire to target non-delegation doctrine as such, but rather from a very long project investigating the relationship between legislative power and executive power at the founding, depending on you count, 8 to 10 years of sort of virtually full-time immersion in 17th and 18th century sources, looking at how the concept of executive power played out, especially vis-a-vis legislative power in the political theory and legal doctrine of the time. This article, or the article that I'm discussing today, flows from the findings of that research project, and in particular flows from the findings of what it means to be executive power. If the executive power is vested in the President of the United States, the question is, what does that mean? As a general matter, the literature recognizes three possibilities. I'm going to focus here only on the second two, which are really the ones that are genuine contenders. The law execution theory is the view that the executive power is quite simply the power to execute executive instructions. And we can have a debate about what it means to execute and the entailed implications of that grant at the margins, but effectively it leaves the president in his or her executive capacity, that is to say, possessing the executive power, simply an empty vessel, instrument of the legislative power, carrying out the instructions from the legislative power. By contrast, the royal residuum theory, often called the vesting clause theory, grants a power to the president that is in fact a suite of powers. It looks to what's called the royal prerogative in particular as the referent, and concludes that whatever powers the English crown, the British crown, possessed at the time of the founding, those are contained within the executive power because they are powers possessed by an executive, except insofar as the Constitution otherwise allocates them. As that separate project has shown, it's not even a close call. It is absolutely 100% certain that the law execution theory is the right one. And that brings us to this project, which is in the course of doing this work, and in particular interested in confronting the idea of a thick royal-like power for the executive branch, I kept on coming across gigantic delegations, both before and after the founding, that struck me as radically at odds with what I myself presumed to be at least something with some grain of truth, which was the idea that there was some non-delegation doctrine at the founding. I wasn't particularly interested in pursuing it, but it kept popping up and kept popping up. So I started taking notes, walked down the hall to my colleague, Nick, and said, hey, do people really think that there was a non-delegation doctrine? Because I'm pretty sure there isn't a non-delegation doctrine in the late 18th century, and maybe at some point you and I should write about that. And we sort of joked about it, and it was something that we pushed off stage for some later point when both of us didn't have other things to do, because it didn't seem like it was actually a very pressing project. Then Gundy happened, and walked down the hall. Actually, Nick walked down to my hall and said, so we're going to start working on that project now, and extended the research from the effectively pre-ratification research that I had focused on. And Nick tackled the immense project of working through the 1790s legislative materials. And the upshot is there simply wasn't anything like a non-delegation doctrine at the founding. It is like to put the burden on those saying this, that they must show people saying there wasn't, is like saying you have to show me a list of 15 people saying that purple dragons didn't exist. I mean, they didn't say it because it wasn't there, because it wasn't there, because it wasn't there. The last conceptual point I want to make before, and Katie, what do I have? 2 minutes left? 3 minutes, fantastic. All right, 3 minutes left. The last conceptual point I want to make is essentially the big picture architectural understanding of the three vesting clauses, certainly the first two vesting clauses, from which this like absolute logical entailed conclusion follows, which is that there's no problem with delegating authority to the executive branch. Again, back to this idea of legislative power and executive power is detailed at immense length. The following quote from in prior work, the following quote from Rousseau summarizes the simple, naive, frankly, really boring understanding of what executive and legislative power were. These weren't things that like wise thinkers were stroking their beards about. They were really simple, mechanical, concrete concepts that related to instructions and carrying them out. Rousseau says, every free action is produced by the concurrence of two causes, human action, that is. One moral, i.e. the will which determines the act, and the other physical, i.e. the power which executes it. My brain wills something, my hand does it. He goes on to say, by way of example, when I walk towards an object, it is necessary first that I should will to go there, and second that my feet should carry me. If a paralytic wills to run and an active man wills not to, they will both stay where they are. So the idea is you have a thought, you implement it. Now, of course, this is naive and indeed incorrect in reference to like modern understandings of how the brain-body connection works. But here's the cash out in terms of how they thought about things when they used the standard, boring, dull phrases legislative and executive power. The body politic has the same motive powers too. Here too, force and will are distinguished. Will, that is the formulation of authoritative instructions under the name of legislative power, and executive power and it looks like I messed up with the quote. I've killed part of the quote, but executive power is the second part, the power that execute what the will instructs, right? So it's an incredibly simple construct in which to possess the legislative power is literally nothing more than to possess the power to issue instructions authoritatively. To possess the executive power is literally nothing more than the power to take instructions from an authoritative instruction giver and do them. Now, here's the thing. And what do I have, Katie? 1 minute? All right, this is going to be quick. Here's the really interesting thing that I want to leave you with to unsettle what your understandings might be about what executive power is. Here's the puzzle. They regularly talked about legislative service and about legislative actions as executive power. How could that possibly be? Congress imposes a minimum wage. That makes the employers pay workers a minimum wage. From the employer's perspective, and this is the familiar perspective and the intuitive perspective, and like, it's really weird to talk about it any other way. Congress's vote was an exercise of legislative power. Of course it was. It has imposed a new rule of conduct. The body politic has willed an instruction, and this must happen. And if it doesn't, the executive will come in and enforce it. Well, how is it then that legislating was also said to be an exercise of executive power? That simply doesn't make any sense, right? Pardon me, an exercise of executive power. That simply doesn't make any sense, right? Well, the answer is on the very simplistic construct. It makes perfect logical sense, and it accounts for otherwise inexplicable discussions of legislators acting in an executive capacity, of the Continental Congress being an executive body, and so forth. Think about it this way. Voters elect Congress to pass laws for the public good. Congress is therefore authorized to pass laws for the public good. From the voter's perspective, Congress's act of imposing a minimum wage is an exercise of executive power. That's because Congress is acting as the agent of public will in executing the implicit and sometimes, by the way, explicit instruction from the electorate to carry out certain kinds of general efforts to make the public good better. There's, of course, lots more to say, but as soon as you take this construct and pull out Congress and plug in the agencies, you'll see what follows, which is there simply isn't any problem with the idea of some entity promulgating authoritative, private, people-binding rules and so forth, and talking about that as an executive power. And once you pull that bit of the Jenga stack out, the whole rest of the thing comes to pieces. There wasn't any non-delegation doctrine at the founding.
And instead of imposing a moderator prerogative to ask the many questions I have, let's just turn it over to Elon.
Thank you. I was thinking of changing my virtual background from yesterday. I volunteered as a judge in a high school civics competition, but somehow I felt it would be appropriate to keep the background for the discussion in light of recent events. Well, thanks so much for having me on this panel. I think I'm on this panel because I have a paper called Non-Delegation at the Founding. It's forthcoming in the Yale Law Journal, and it's partly a response to Julian and Nick's paper, Delegation at the Founding. And so let me just talk a little bit about their paper and sort of my disagreements with it, although I do think my paper goes a bit broader and in response to numerous papers that have come out on the non-delegation doctrine lately. Well, Julian and Nick make this claim that we heard that there was no non-delegation doctrine at the founding and that the question isn't even close. I'd like to say at least one good thing about the paper. First, I think it's a great contribution to originalism. I think to make claims such as theirs, they have to believe in the originalist project. They have to believe that historical research into legal materials is possible and that it can provide correct answers. And so in some respects, and maybe I'm being a little flippant here, their paper, I think, is something of a boon to originalism. But more seriously, their actual historical their historical conclusion, I think, gets the answer backward. The claim of my paper is, that there was a non-delegation doctrine at the founding and that there actually was almost no evidence to the contrary. My first and briefest point, Julian didn't talk about this much today, but in the paper, he notes that James Madison had sort of an idiosyncratic non-delegation view. But by my count, and I go through sort of the debates, Madison, Sherman, Livermore, Hartley, Page White, Gary Vining, Williams, Livingston, Nicholas, Gallatin, McDowell, Key Rowan, John Jackson, Alexander Smith, John Quincy Adams, and John Marshall all made non-delegation statements, non-delegation principles, multiple occasions in Congress. And on some occasions, a majority of the House of Representatives agreed by rejecting proposed delegations of power. I do want to mention Julian and Nick have some really interesting a discussion of John Locke, where they claim that John Locke distinguishes between delegating power, which is okay, and permanently alienating or transferring power, which they say is not okay. But even if that's a distinction that Locke adhered to, which I doubt, by the way, it's not one that the founders adhered to. All of the representatives that I just mentioned, when they were talking about non-delegation, they used the terms delegate, transfer, and alienate interchangeably. And the most common word actually was transfer, which is the exact word Locke used to describe this concept that modern originalists use to describe non-delegation. I should add that even, the evidence that there was no non-delegation or a weak non-delegation is itself pretty weak. If going to the post-Rhodes debate, Representative Sedgwick, the proponent of the amendment that would have delegated the power to the postmaster to pick the roads, thought there was some non-delegation doctrine. He just wanted to leave the particulars, right? He just thought that particular delegation wouldn't violate this non-delegation doctrine, right? He said he wanted to, quote, leave the details of the business entirely to the Supreme Executive because he thought it sufficient that the House should establish the principle and leave it to the executive to carry it into effect. So maybe there was a non-delegation doctrine and it was relatively weak. It didn't do much work, but that's very different from saying that there was no non-delegation doctrine at the founding. I do want to talk about something that Julian, discussed today in his presentation and is on his paper. He says that executive power is simply the power to execute instructions. And he had a whole slide about how this means that Congress, therefore, also exercises executive power from the perspective of we the people, because they're delegating the instructions, they're executing the instructions, we the people delegated to Congress in the Constitution. But that seems crazy to me in a way. I don't know that can be right. We execute instructions all the time. We execute a will when someone dies. We execute an order from a superior at work. That doesn't mean I'm exercising the executive power when I do that within the meaning of the executive power in the Constitution. So something else must be going on in the Constitution when we talk about legislative, executive, and judicial power that Julian and Nick just don't really probe in their paper. Okay, so that brings me to the last thing I want to talk about, which is the actual practices of the first Congress and the distinction between regulating private rights and public rights and official conduct. Almost all, perhaps all of the delegations in the early republic involved public rights and privileges like veterans benefits and public pensions. Some formalists have suggested to me that, therefore it's okay. That's the distinction. I'm actually not sure that's the distinction, or at least I don't think this means Congress can freely delegate power over public privileges. I just think it's probably true that Congress has more discretion to delegate more to the executive when it comes to public privileges. But Congress, I think, still has to make the important decisions. Should we have a welfare program at all? Who's eligible to it? How much are we appropriating for it? Right? What are the general standards for determining how much each individual gets? Right? So even in these delegations involving public rights from the early Congresses, I do think Congress resolved these important questions. Now, it could be, though, that matters of private right, private conduct as opposed to official conduct and as opposed to public privileges are more important and require correspondingly more detail from Congress. This is what James Madison appears to have had in mind in his report of 1800, and I'll just quote it briefly. To determine then, he said, whether the appropriate powers of the distinct departments are united by the act, in that case, authorizing the executive to remove aliens, the Alien Friends Act, it must be inquired whether that act contains such details, definitions, and rules as that pertain to the true character of a law, especially a law by which personal liberty is invaded, property deprived of its value to the owner, and life itself indirectly exposed to danger. So it seems to me that there was a non-delegation doctrine. The question seems to have been the one posed by Chief Justice Marshall in Wayman against Southard, as Congress determined all of the important subjects, leaving mere details to the executive. This is a bit different than the formulation in the dissent in Gundy. I think it means Congress might be able to regulate private rights, but those private rights are surely going to be more important, and maybe more specificity is required, or maybe there's some other requirements there as well. But I will desist because I'm sure I've gone over my time.
Before we go to Jillian, can I just give you another minute and a half to explain? You've proposed an importance subjects theory of non-delegation, and I'd like to know what exactly that would look like and what parts of the administrative state would survive under your important subjects theory.
Yeah, so I haven't fleshed this out completely, though I did file a brief in the Arizona Supreme Court in some coronavirus litigation that I'm involved in. I thought the brief would get more attention, but I filed it on January 6th. So maybe that explains a little bit of the lackluster interest. But I propose there that private rights can be regulated, in fact. And I think this puts me in a very different camp from Justices Thomas and Gorsuch and Philip Hamburger. What I basically argue is that at least three conditions have to be met if Congress is to delegate the authority to regulate private rights. The first is the authorization to regulate private rights has to be explicit. It can't be hidden in a more general grant of authority, to regulate in the public interest, or in the case in Arizona, a grant of all police powers in an emergency. I don't think that's quite sufficient. The second condition is the category of conduct that's covered, I think, should be narrow. It can't be this roving commission over, all human conduct, the entire economy, kind of like the Justice Cardozo point. And by the way, the Supreme Court says this sometimes. I think in Whitman it said, the scope of the delegation determines how precise the standards have to be. But as far as I know, it's never actually given sort of teeth to that. And then I argue that the standards have to be more precise when they regulate a private conduct. And I'll just say one thing, I know I'm going over, but in 1852, Congress authorized steamboat inspectors to make passenger limits on steamboats and to make rules for passing ships for public safety. It strikes me that those should be perfectly plausible. It was expressly authorized to regulate private rights over a narrow category of conduct. I mean, it's got to be constitutional to delegate that kind of power. So I think, that's just the private rights side of the equation.
Great. Thanks, Elon. I'll just tell the panelists aren't monitoring the chat. So I just want to throw out Jack Bierman's typically Jack question, which a lot of people have. Why should we care what the framers thought? How does that help run the country today? So Jillian, I think, will bring us more to the modern era.
That is a great lead-in. Thank you, Jack. And first of all, can everybody hear me? All good? Okay, so thanks. I'm really delighted to be part of this panel. I think that the recent historical work that we're getting from Julian, Nick, and Elon, and so many others, Nick Perillo, Kristen Chabot, John Harrison, just a few. I mean, this is by far the best outcome from Justice Gorsuch's opinion in Gundy. So maybe it does, in fact, have a silver lining. But I'm not a historian. So rather than speak to the merits of this historical debate, my brief comments are going to go in a different direction and focus on why has delegation risen to the fore of public law debates today? What impact will or should this history have? Thank you, Jack. And what considerations should factor into contemporary thinking about delegation? So first, why today? And if you leave aside the 18th and 19th centuries, anxieties about the scope of delegation have surfaced periodically over the 20th century as well. Non-delegation, of course, had its heyday in court in 1935 during the early New Deal. Its appearance at that period and in subsequent periods is not accidental. Although it's occasionally been raised by liberals like Skelly Wright, non-delegation is overwhelmingly an arrow in the conservative quiver. It is used to push back at the administrative state and regulation. Initially, in the 1930s, it was raised as part of a conservative attack by business conservatives on the constitutionality of the expanding administrative state. And its recent revival is part of a similar burst of conservative attacks on administrative government. These are advanced not just by conservative justices on the court and scholars, but by business conservatives groups going back to Lewis Powell's famous memo to the Chamber of Commerce in the early 1970s and before. And these attacks take a variety of forms. Non-delegation is only one of them. they often have a structural and formalist constitutional character. So the resurgence of non-delegation is part and parcel of the recent rise in appointments clause challenges, First Amendment attacks on regulation, particularly also part of judicial pushback on agency deference. And I think one of the things I hope we will talk about today is the extent to which these historically based attacks on delegation actually really would call the constitutionality of the Minister of State into question. I think there's some interesting debate on that. I do think, however, that the impact of these attacks on delegation shouldn't be discounted, even if only a few particularly broad delegations end up being invalidated. For example, grant of police powers in Arizona, those invalidations could have a significant impact on the ground, see, e.g., pandemic. More importantly, delegation arguments will and are used already to argue for narrowed interpretations of agency authority and to reject deference. And that resultant judicial pullback on agency statutory authority has a big practical impact. And I think that's actually, quite honestly, what the name of the game often is. A third effect that I do want to emphasize is that I think these attacks on delegation raise uncertainty and undermine perceptions of the legitimacy of administrative government. And even if that impact is largely rhetorical, I would put out there that I think we have seen over the last 4 years the very real harm that constant rhetorical attacks challenging the legitimacy of government and bureaucracy can have. And we saw that quite starkly this week. I want to be clear, there's absolutely nothing wrong with conservatives arguing for constitutional limits on deference, just as there is absolutely nothing wrong with progressives in response regularly arguing for the opposite. My point is more that I think it's important to underscore that what is going on in both cases is constitutional construction, not some uncovering of neutral constitutional truths. Or to put the point differently, the impetus behind non-delegation's resurgence is a contemporary one. It is not a historical one. And a concern that I do have a little bit about the historical cast of the current debate is that it tends to occlude the broader normative and ideological basis behind non-delegation's resurgence. Julian and Nick acknowledge this. They really engage this point. And I think, in fact, the motivation behind their piece is to show that the invocation of history is a red herring. But I do think this risk nonetheless remains, and we end up debating the significance of post roads and post offices, what can be read into the early Patent Act, statutes, delegating authority to borrow and pay off debts, all of which, as an ad law and history geek, I find actually really interesting. But I do think we risk losing sight of the key question of how should contemporary reality factor into constitutional analysis of delegation. So, I mean, even if non-delegation doctrine does have some basis in original understandings, that doesn't mean we should start scrutinizing the constitutionality of delegations more closely necessarily. And a lack of historical basis doesn't mean that leniency necessarily follows either. How much time do I have, Katie? 2 minutes, perfect. So how should we approach delegation? And what I would begin with is by saying we live in a world that is marked by broad delegations and complicated administrative regimes, where many of the basic services and supports people rely on and expect from government necessitate an extensive administrative state. Whatever history says, I don't see that reality changing. And I think attacks on delegation need to grapple more with our now entrenched historical practice of delegation, well over 100 years old. 120 more of modern delegations, and what follows constitutionally, from that practice. So in that vein, I've argued in some prior work that the reality of delegation actually makes the modern administrative state obligatory against a background of broad delegations and rising presidential unilateralism. The administrative state really performs essential constitutional functions in supervising, constraining, and effectuating executive power. But that the way in which delegated power is wielded is too often not part of the analysis of the constitutionality of delegations. Another flaw that I see with current non-delegation arguments is that they focus solely on that initial delegation of authority in the substantive statute at issue, and that ignores the additional mechanisms of congressional control, including in particular post-delegation control by Congress through appropriations and oversight. And if the concern underlying delegation is that agencies are exercising legislative power by setting policy on important subjects, and if that concern has constitutional legs, then at a minimum, all of the ways Congress wields influence over agencies need to be considered in determining the scope of an agency's authority and whether or not that concern is really live in particular context. I'm happy to say more about this appropriations point in the Q&A. I also wanted to flag one final point, which is that any effort to revive non-delegation doctrine has to contend with what many, and probably most pointedly Justice Scalia, identified as a fundamental problem with enhanced scrutiny of delegations, which is the task of identifying a test that is implementable and does not simply turn on judicial perceptions of what counts as important in policy setting versus filling out the details. Because why should we necessarily turn to judges' views of that rather than Congress's? And I think the very historical debates that we've seen that we'll be hearing about what counts as important or not in these early historical statutes show that actually coming up with that kind of test is very difficult indeed. Thanks so much.
Terrific. I'd like to go back. Mike, I think you can put us into the Brady Bunch frames now. I'd like to go back to Julian and just give Julian and Elon a chance to respond to what's been said. If you have anything you'd like to throw in before we go to the questions. Julian?
Starting with me?
Yeah.
Gosh, well, so lots of things. So I would say two things are worthwhile flagging. And the first is the inability, I think, at some level for a simple verbal exchange among folks in now a Brady Bunch panel to effectively convey the comparative persuasiveness of the work in a world where that persuasiveness emerges in part from thoroughness, care, and precision. Alana's litigating these questions now. He's an able advocate doing the best he can with what is historical matter is an awful hand. And maybe it's just this week making me blunter than usual, but when he says lots of people asserted a non-delegation doctrine, he is, I'm afraid to say, misrepresenting the historical record. And I would just ask the folks who care about the right answer to these questions, maybe to use this engagement today as a way to think about framing the most important things that you want to look at if you're looking for the right answer, and then to read the papers. It's not a close call. The second thing I want to say, and there's lots of things to talk about the way in which, there's so many different directions to go. But the second thing I really do want to say is this. The ire that I feel, frankly, about originalists having made this up 10, 15, 20, 30, 40 years ago in papers claiming that something existed at the founding that plainly didn't, I think in some respects is prompted by the lessons that I took from Justice Scalia. And I'm not saying this in a concern trolling way. I'm not saying this in a gotcha way. I'm saying this in a way that, like, I really agree with Justice Scalia about if we care about the original understanding and if we care about the use of history, it has to be in terms sort of like these. And I kind of think it might be useful to pull up some quotes. I don't know if it's possible. It's not the end of the world if I can't. But Katie, is it possible for me to share in this format or no? All right, let's see. If I can, terrific. If I can't, we'll not worry about it. Sugar beans. Now let's go back here.
But I would like to keep the conversation. Okay, here we go.
Yep. I wanted three quotes. Justice Scalia and Obergefell talking about substantive due process. I would ask originalists and those uncomfortable with the idea of ruling from the bench to think about their reactions to substantive due process, reactions that I, in many respects, share, and think about how they apply here. Scalia and Obergefell says, the practice of constitutional revision by an unelected committee of 9, always accompanied by extravagant praise of liberty, robs the people of the most important liberty that they asserted in the revolutionary period, which is the freedom to govern themselves. Justice Black, dissenting in Griswold, says, the court talks about a constitutional right of privacy as though there is some constitutional provision or provisions forbidding any law ever to be passed which might abridge the privacy of individuals. But there is not. There are, of course, guarantees in certain specific constitutional provisions which are created to serve the larger interests of privacy. Think about how this exact same line of reasoning applies to the separation of powers. And then finally, Glucksberg. Glucksberg rejects precisely the approach that as a body, the originalist scholarship asserting that this non-delegation doctrine takes, which is to take 3 or 4 sources, a couple of lines stripped from political theory claims, wave their hands and elevate to a level of abstraction and say, and therefore we must adopt a hard-edged modern judicial doctrine. Glucksberg rejects that when it comes to substantive due process. It rejects any approach that would deduce rights from abstract concepts of personal autonomy. Instead, Glucksberg demands a careful description of concrete examples, historically, that the alleged restriction has been enunciated and implemented with regularity on a widespread basis, such that the court dare step in the way of the legislative branches, the executive branches, the political process, and tell them, no, the Constitution does not permit this. And that's my ire. My ire is having learned this lesson from Scalia about causes that are near and dear to me, and having walked back from a sense of feeling entitled to ask the courts for everything I want, and then seeing these lessons and these alleged core commitments being abandoned when, as a whole, they become convenient to political goals of a modern movement. And that is not only ire generating, it is sad.
Thank you, Julian. Elon, do you want a couple of minutes to respond?
Sure. So I'll just say a few things. I think some historical questions are not close, right? But I just don't know that this is one of them. I mean, history is more often messy, and I just think it does a disservice to the wealth of historical materials that Julian and Nick are exploring to say that the question isn't even close. I mean, I think history is messy. We have a lot of these broad delegations in the public rights context. We have, some in Congress when non-delegation arguments were raised, the House nevertheless passed the law, right? But when you look at all the evidence, I think it's overwhelmingly in favor of the non-delegation doctrine, actually, but I don't even claim that the question isn't close. I think it's a messy question. I think the evidence better supports our position, and it's just I would just generally be skeptical of making such a strong claim based on historical material. And the only other thing, I'll say, I guess, a couple more things. Jillian, I don't think you implied this about the January 6th storming of the Capitol, but, just for good measure, I'll put it out there that originalists, formalist conservatives have been, questioning the constitutionality of the administrative state for decades. It was only on January 6th, 2021 that people stormed the Capitol. And I think there's another factor, involved, a determinative factor in the events of last week. And finally, I do want to separate myself a bit from the stronger formalist and originalist claims. Maybe it's because I flirted with functionalism a few years ago, but I think much of the administrative state survives, even with the formalist, or can survive with the formalist approach to constitutional interpretation. So, for example, on the judicial aspect of things, I've proposed in prior work that we make ALJs like true adjuncts, make them magistrate judges, have them submit report and recommendations, to district court judges, kind of like bankruptcy judges do in so-called stern claims. Much of the administrative state will survive with respect to judicial power. My claim about legislative power, how only some really broad delegations would be struck. A lot of what the agencies do is actually this non-exclusive legislative power. Congress could, of course, legislate in more detail if it wants, but it doesn't have to answer all of these questions. I think a lot of that will survive. The closest issue is Humphrey's executor. I do think that's the most clearly wrong from the historical materials. I think Julian disagrees with me on this one. But even if Humphrey's executor were overturned, and that the president could freely remove officers running independent agencies, I think from an appointment power perspective, I'm not committed to this view, but I'm pretty sure Congress can still establish a commission to run an agency and can still require that it be, 4 Democrats and 3 Republicans, or that there still be this bipartisan mix, which would limit the number of appointees, potential replacements if the president were ever to remove someone. It still requires the agency itself to engage in negotiation among themselves, right, and deliberation to ensure that they're based on expertise. So if you deploy the formalist framework on legislative power, executive power, and judicial power, the entire administrative state doesn't have to go away. I think it's reshaped in actually helpful ways, but that doesn't mean it goes away. The only way the administrative state goes away is if the Commerce Clause goes away, if the modern scope of the commerce power is narrowed. That's really where the political beef is, I think.
So I think your comments we've got so many questions in the chat that are so great. And I know I'm sad already that we're never going to have time to get to them all. But I think a lot of them concern what you were just talking about. I think to some extent, Julian and Elon and the other scholars are talking past each other. I think the real debate is, where is the line between what is delegable and what is not delegable? Peter Strauss got the first question in the chat along these lines, and he said, how important to originalists is how the founders would have described the legislative power? The discussions have all focused on rulemaking, but at the time, legislatures set rates, issued corporate charters, granted monetary relief from governmental injuries, etc. Would a real non-delegation doctrine undo, for example, the Court of Claims? And let's open this up to Jillian first. To where do we think we draw the line?
Right. I think that just is a profound issue here, right? First of all, it is interesting. We've had this in the historical work. There is this very interesting discussion about public rights versus private rights. I think that Elon alluded to that in his comments. But one of the things that Peter's points out is that the early American state and government was a profoundly developmental and distributive one. The activities that were important subjects to that state were largely, grants of various kinds of benefits, and the things that Nick Perillo and Christine Chabot have talked about in terms of paying off debt, or raising tax revenue and so forth, customs and so forth. So those areas really are. You have to think about. I think when you're thinking about how non-delegation precedent from the founding would apply, you also have to think about how important those areas are to the nature of the state at the time. And once you start doing that, this whole category of what's an important subject just starts, I think, to show how amorphous it really is. And I think there's, when you read these papers, and I actually echo Julian very much, these are great papers and they deserve to be really read in full. But when you read them, one of the things that comes out is the extent to which there are disagreements on how to read specific statutory provisions as broadly or narrowly. And that's a very interesting debate, but I think it also showcases how very hard it is to come up with a principled line that distinguishes what is an important subject, or what counts as filling up the details, and that we really shouldn't lose track of the fact that non-delegation doctrine as it exists today is often a doctrine that emerges from views about institutional competency, and how well courts could actually implement a line, and not, again, some historical distinction between the legislative power and the executive power.
So, Julian, can I ask you to weigh in on this? Where would you draw the line? I think Elon's article points out that a lot of people had what we would think of as non-delegation concepts at the time of the founding. I think your point is more that they regularly made pretty broad delegations. So where would you draw the line between what's delegable and what's not?
I don't want to start. Oh, sorry.
Sorry, good. I'm glad it was. I thought it was Julian. I was like, that's a question for Julian.
Sorry, Julian. Yeah.
So I want to start by contesting the premise in a very important way, and then moving on. There weren't a lot of people who had non-delegation ideas at the founding. They are non-existent pre-1789, and they are non-existent in the first Congress, including across an astounding array of delegations. And I'm sorry not to quite answer your question yet. I'm going to be happy to, but this is really, really important. Like, my only contribution here is this is all nonsense and stop pretending. And so I really want to be clear. It doesn't exist, notwithstanding delegations by Parliament to the states, notwithstanding delegations by the states to Continental Congress, states, by the way, that had strong separation of powers provisions of their constitution. Delegation by states, again, with strong separation of powers provisions of their constitution, to the federal government. Delegations by the federal government to the entire Northwest Territories governor to promulgate any law that he wanted to, that could be punished with anything up to lashing and death. I mean, there is an astounding array of instances where, if there was a non-delegation doctrine, even in inchoate and unclear form, somebody would have said it. And it didn't happen, and it didn't happen, and it didn't happen, and it didn't happen. And this, if I don't leave anybody with anything else other than this point, please read the papers. That's what I want to leave you with. Not until the second Congress. Are there the tools in a world where there's a separation of powers provision in the Constitution for an able lawyer to say, hey, look, maybe we shouldn't let Congress consolidate all the powers into the president? You know, I am super sympathetic to that. I am, and a little bit different from Nick in this respect, like I will hold hands with Elon and his compatriots in suggesting all kinds of revisions, especially on the national security front, over broad delegations. I am down, right? Like I do not celebrate those. But you don't see anybody invoking anything like this until the second Congress. And you guys, that's not how doctrines work, right? It doesn't, you don't have a doctrine if it's not invoked. You think about like, and I want to stop here because I want to talk too long. I know I haven't answered your question. So if you want me to, come back to me, but I've talked too long. And I don't want to pick on anybody, but there was a paper and an argument this week that suggested that perhaps Donald Trump ought not to be impeachable because the things he was saying might be protected by the First Amendment. Now, I think that the median view on that in the commentariat, among practicing lawyers, among the people on this panel, I am certain all four of us, again, I don't want to be too blunt, I want to bring myself in, is that is ill-founded and like not grounded in anything that any plausible person could really conclude without being incorrect. But the argument is made. There are tools there in talking about the First Amendment to claim, hey, Twitter's violating my rights by getting rid of me, or you can't impeach me because of the First Amendment. I mean, they're bananas arguments. They don't work, they fail, but the arguments are made, and the founders do the same darn thing. They make all kinds of, they call each other on it, all kinds of stupid made up arguments throughout the first Congress, like saying, oh, you can't do that because it's unconstitutional. Like they do it all the time. And many of these things that are created in the first Congress that extend powers to agencies, to the states and so forth, are contested and opposed. And nobody once says anything about non-delegation. And you guys, that's not how opposition works. If there's even a kernel of a nugget of a atom of a doctrine, there's no delegation doctrine. And I know I didn't answer your question, but that's just so important. I know everybody wants to be nice and say, on the one hand, on the other hand, see, that's not how it is here.
We appreciate your enthusiasm, though, Julian. It's great that law professors feel so deeply about what we do. Elon, you have already enunciated where you would draw the line. Do you want to weigh in? I want to get us to the dangers of focusing too much on history also. But go ahead.
Yeah. Well, I'd much rather answer the Peter Strauss question than the question you just posed, which is a harder one. I think.
Well, let's go to the Peter Strauss question first.
Yeah. So I think both formalists and functionalists have sort of gotten this debate wrong, and I've started writing this in some of my papers, but I really need a more extensive treatment. I don't think power is neatly divided into either legislative, executive, or judicial power. I think there is exclusively legislative power, whatever it is. That's the question in this panel, actually. What is that exclusively legislative power that only Congress can exercise and can't delegate? Then there's exclusively executive power, things that only the president can do. Maybe that's prosecution. There's some debate about that. Peter Shane has a great paper arguing how maybe that's actually judicial. And, so there could be debates about the scope of what exclusively executive power is. And then there's, I think, exclusively judicial power, which I think, and I would submit, is the power to deprive someone of life, liberty, or property, to adjudicate cases under existing law involving life, liberty, or property. That's what I think are exclusively judicial. But then there's a whole category of government power, maybe most government power today, maybe 80% of government power can be done more than one branch. And I describe this power as non-exclusive power. And this is the details John Marshall was talking about. Congress could always legislate with more specificity, but he could also, the president, Congress could delegate to the president, as they did to President Washington, the power to make certain interstitial rulemakings, like with the Invalid Pensioners Act of 1789, where George Washington and Henry Knox decided how you're going to prove that you're an invalid pensioner, when the payments were going to be made, how many installments, and so on like that. We have that regulation. As for the Court of Claims question, this is I don't think it's an exclusive power. I think it's a non-exclusive power. Why? It's not judicial power because it's not a traditional private rights case. Maybe it's sovereign immunity if the government doesn't have to consent to be sued, then surely it can consent to be sued in an executive branch tribunal rather than in a judicial branch tribunal. And once you realize that Congress is the only one that can waive sovereign immunity, Congress often decided through private bills, and through committees and petitions, to resolve claims against the government. So claims against the government could be resolved by any of the three branches. The fact that Congress historically did it doesn't mean it was within that category of exclusively legislative power that only Congress could exercise. I think Congress exercised a lot of power that was not exclusive, that it exercised, but it could also give away at some point in the future, as it did with the Court of Claims. On the historical,
So where, let's just hone in on this for a couple more minutes, but before we turn to the danger of history, Jody Short was just saying in the chat that she thinks Julian really did answer the question about where the line is, that if there is no non-delegation doctrine, then the line is simply what Congress and the president agree to in duly enacted legislation. Elon, I think that your proposal has the problems that Jillian has pointed out, that the line is more indeterminate. That really gets us back to the question, we've had a bunch of questions in the chat about the dangers of focusing on history and why originalism. First of all, we are not historians, at least most of us are not. Second, the thought to me of new historic evidence showing up and changing constitutional doctrine is very unsettling. Third, as Jillian already pointed out, focusing so much on history is really masking modern value judgments that are at the heart of the debate. And I think anybody who hasn't read Jillian's fabulous Supreme Court forward about basically relitigating the soul of the New Deal is well advised to read it. And relatedly, why originalism? We had a few questions, one from Kent Eggert and others. Why originalism instead of textualism, instead of some other approach? What role does interpretive method play here? And let's go back to Jillian for a minute to tee us up on this, if you want. Jillian or Julian to start us off.
So why don't I'll just say a little, but then to keep it more interactive, I'll try and keep it short. I think that you can't avoid those questions that surround any constitutional debate about what your interpretive method, what's the appropriate interpretive method. I tend to prefer a more eclectic approach of the kind that across the court, I think most justices use. So I tend to put more weight on historical practice. And that's why, to my mind, what really matters is that delegation is part of an entrenched aspect of our contemporary government. We cannot change that. We need constitutional doctrines that work to control and address the realities in which we live, and delegation is one of those. So that, for me, precedent, there is lengthy precedent upholding delegation. All of that would be not necessarily overturned. Again, the results might not change, but certainly the reasoning would be somewhat called into question. The text can get you so far. I don't think it gets you all that far. The history we've been talking about. And then there's the normative values and how much weight to give to very important constitutional values, not just checking power, but also effective government. And to me, the way to look at those and the way to think about delegation is less to try and find an ex ante limit on what can be delegated, and more look at what happens when you delegate, and look more ex post. Look at the kind of controls Congress exercises. Look at the kind of controls that the courts exercise. Look at the kind of controls that the executive branch exercises in a variety of ways, and think about whether the conglomeration of a range and just the multiplicity of complex relationships in administrative government address the very concerns that underlie delegation doctrine, and do it better than looking back at what the framers thought.
Elon, Julian, do you guys want to respond?
Sure, I'll take a first crack at it because Julian is slower at the unmute button. So I guess I'll have the historian's question, is a challenging one, and lots of people have debated this, and it requires more extended treatment. So I say this not flippantly, it's not a complete answer, but it's true that most lawyers aren't historians, but we aren't economists either. We aren't moral philosophers. We aren't public policy experts, yet substantive due process doctrine requires us to partly try to be moral philosophers. Tort law requires us to be economists. Some administrative law requires us to have economic background. At the end of the day, lawyers depend on a lot of material from lots of areas of life because law touches everything in life. And, the fact that we're not experts in every particular field doesn't answer the question of, whether these materials are relevant to legal questions, which itself, I think, is just a question for law, not for history, not for, economics. And so that's just a partial answer. It's a partial answer. It's an incomplete answer. And I grant that. But then again, we have a sharp taskmaster. So that's all I'm going to say on that. Why originalism? It's a good question, but I don't think in a panel like this we have to reinvent the wheel. We can just assume originalism is relevant to the modern Supreme Court and just debate it that way and let other people sort out whether it should be this method or some other method. And I'll add, like, how many people get asked why living constitutionalism? In panels like this, like somehow living constitutionalists don't have to defend themselves, or do they really? Well, okay, I'm young, the junior scholar on this panel, so I stand corrected on that. Well, I look forward to hearing that question in a future panel, which I'm a part. The other thing I'll say is just on Julian's historical sort of claims, which I think, I don't know, I'm skeptical. The things Julian mentioned in his last answer, And I think you do this more in the paper, Julian, is like you try to draw this clear line from the Statute of Proclamations from the 1530s, that delegated power to King Henry VIII, which was repealed the next year. And, Blackstone detested it. The colonists detested it. And you cite the Statute of Proclamations as support for delegation, legislative delegation. And you draw this clean line of delegations from the 1530s to the 1600s, the 1700s, as though there was no change in political philosophy and intellectual history. And, those delegations, like to territorial governments, it's a vertical delegation, not a horizontal delegation to a co-equal branch. And, there are explanations for all these things. And I just don't think it's like a clean line as you describe it.
Julian, do you want to jump in?
When Alon can cite a single objection to the states delegating wholesale power to the Continental Congress over a wide range of topics that affected private rights on very important matters. A single objection to Parliament granting power to the colonies and by the prerogative to the royal governors. A single objection to the delegation by the federal government of any kind in the first Congress over all kinds of important matters, including both private rights and important matters. We can talk about the Statute of Proclamations. I think if you read what I say about the Statute of Proclamations, it is not that it is a praised item that stands for what they favored. And unfortunately, and I guess I'll be blunt, that's an example of the effective advocate, is to look for a line and reframe it in a way that serves a larger argument. We don't say the Statute of Proclamation says that the non-delegation doctrine didn't exist. We talk about the Statute of Proclamations is something that was opposed. I was going to be quick, and so now this is my quick answer on the question presented, which is because I've talked too much already. As to originalism, why originalism? I think that most people think that what the founding understanding was is at least relevant to interpretation. So in terms of like the value of this work and this debate, I think it's relevant to everybody. It's certainly pragmatically relevant because of the current makeup of the Supreme Court, and it's also just interesting. And so that's for me, that's a sufficient justification to ask these questions. I personally am the furthest thing from an originalist, but even I think that as you think about the right answers to questions are, be useful to start with how they thought about it when they started off.
Can I turn us to a slightly different question, which is it concerns more the relationship to presidential power? As moderator, I get to turn the discussion to my latest concerns, and especially in light of events in DC this week. A lot of people in the chat have approached this question, but basically, what's the alternative to delegations to agencies? If we start ratcheting down on Congress's ability to delegate, would that not first of all, exacerbate gridlock in Congress and also exacerbate the problem of unilateral presidential action. Christine Chabot, is it Chabot or Chabot? I'm sorry, I don't know how you pronounce your last name, who also, by the way, has written a terrific article on non-delegation doctrine, points out that early Congresses did have mechanisms for checking executive power. This gets back to Jillian's proposal that we have more of a holistic approach to non-delegation questions, but doesn't ratcheting down on non-delegation necessarily enhance presidential power in the modern structure? Isn't that a problem that we need to contend with? I guess not.
No, I'm happy to. No, it's a problem, but I'm happy to jump in. But I've been answering first, so I thought maybe one of the others would like to take first stab, and I can come in later.
Elon, do you see that as a problem? And I'll throw out, I can throw out another bit that Alan Morrison pointed out. The chat has gotten so long, it's hard to find things. Alan Morrison says, I'm not neutral in this debate as I was counsel for petitioners challenging the delegation to the president to impose tariffs in the interest of national security from restricting imports in AIIS versus US. We drew the line. There was nothing that the president could not do under this delegation, and DOJ never pointed to anything. That is a line, and even after Gundy, the Supreme Court denied cert. So isn't that a problem? Aren't the same originalists who are espousing non-delegation doctrine, a robust non-delegation doctrine, the same ones who are propounding very strong unitary executive theory? Isn't this essentially undoing our separation of powers framework?
Well, on this panel, you won't get as much disagreement on this probably because both Julian and I assume Jillian, think that the executive power is only the power to execute law. So the answer is, and it's not this residual grant of anything. And so if Congress just does less because it's required to by the Supreme Court to legislate more and it doesn't have the capacity or the will, then I think that means the executive also does less, except to the extent that they jump in and, claim powers that aren't there historically. Again, unitary executive, I think it's sort of a misnomer. Unitary executive, and the conservatives, formalists could be blamed for the misnomer. Unitary executive just asks the question, who exercises the executive power? It doesn't answer the question of what is the scope and content of the executive power, which Julian and I think, agree are is much narrower than many formalists think.
Push back a little bit, not because I disagree with the way you've set that up, Elon, but just because I think, again, it ignores the reality of government and of how delegations have functioned throughout government, and how things like expanding presidential control and directive authority, which are tied to claims of unitary power, end up worsening the impact and raising some of the concerns that underlie delegation that might not be in other ways. My view has been that there is a duty to supervise delegated power, that delegation comes with a duty to supervise, but that is not a duty to direct. And again, I feel like I'm a little bit beating a dead horse, but if you take a more holistic approach and you look at what is the overall system through which delegated power is being wielded. What are the checks? You've got checks of division of power within the executive branch. You've got checks of the courts reviewing that. In what ways are the checks there? And to focus on Katie's work, if that's the way we start thinking about it, maybe we have to start thinking about what are the judicial or other checks on presidential action more directly if the president is going to start playing more of a role of a kind of uber statutory agency. And I think what so where I would push back is not necessarily on the concept, but if you focus on how delegation and power works in government, I think that you realize that there is a concern about aggrandized and agglomerated power in a single set of hands that happens as a matter of reality when you start expanding presidential control, and that the more you make it impossible for Congress to act because Congress has to legislate so specifically, or where you don't pay attention to all the different ways in which Congress acts, which is also by oversight and also by in investigations in specific ways, and also by appropriations, and you focus only on what happens when they enact authorizing legislation, and particularly substantive authorizing, not even authorization of appropriations, which Chris Walker and Jonathan Adler have emphasized as important here, then you're going to just end up expanding presidential power. And that, if your concern is about, in some ways, aggrandized power, which I think is one of the underlying concerns of the non-delegation doctrine, that ends up being somewhat counterproductive.
I will just, if I'm allowed to do this, agree with both panelists. And I think that it's a coherent agreement. And I bet that Alon might even agree with what Jillian just said. I agree with Alon that as a formal matter, his description of how the larger implications of this would play out are right if Congress can't enact statutes and the president can't do it on a certain view of the executive power, et cetera. I think that's exactly right. And Alon scrupulously and correctly describes what it means to make a unitary executive claim as a pragmatic formal matter. But I also would co-sign entirely Jillian's prediction about how that actually plays out in an actually functioning legal system. And what we're actually going to see is that something is going to emerge to fill the void and so forth. So I actually think I agree with both of them.
So I think they're going to cut us off in about 3 minutes. I think we end at 12:15. Is that correct, folks? So I'd like to, on the line of prognosticating, I wonder if you guys have thoughts about the kind of non-delegation case that the Supreme Court might take up, the extent to which this scholarship might influence the court, where you think the court might draw the line. Is it going to look like the Gundy dissent, or is it going to look like something else? What do you guys think is going to happen? We promise not to hold you to it.
So I'm going to jump in.
I can start quickly just because I don't mean to leave everyone up for the position of going first. I don't want to talk too much. My thought is that I don't know. I go back and forth at justice by justicism level at how scrupulously I think they pay attention to stuff like this. But I don't feel like my prognostications are worth a dime. I just hope that they will think in their heart of hearts about how they feel about substantive due process and about the kind of historical showing they demand when it comes to constraining the political process and substantive due process. And they will reflect on how the implications of their feelings on that score might logically transfer to this area.
I was just going to jump in because for modesty reasons, I thought maybe Ilan and Julian might not want to answer the question of whether or not the Supreme Court is going to cite their work. But I do think it's the kind of thing, scholarship that the court, given its focus right now, may very well be interested in. My own guess is that what we're going to start seeing, what we've already seen, is non-delegation not as straight up challenge, but non-delegation as very, very narrowed statutory interpretations. Increasingly, agencies have much more restricted authority, and it's justified in a variety of ways on the grounds of non-delegation.
And I'll just add to that that's exactly the argument I'm making in the Arizona litigation, to which we alluded earlier. It described that if in fact all police power means what our governor seems to think it means, then that creates a non-delegation problem. But there's a way to narrowly construe the statute, which I actually think is the best construction of the statute. And I just think that's just a better litigation strategy. It's a safer approach for the courts to take. And I wouldn't be surprised if they did that in other kinds of circumstances.
So we have 2 minutes remaining. Any closing remarks from our panelists? So I want to encourage everyone. The chat has been remarkable here. Amanda has said that she will email it to me when we're done. And what I will do is circulate it through the administrative law professor's listserv so that the panelists can have some chance to respond to more of the questions. I feel like we could go for another hour on this, but alas, we ran out of time. But I will circulate the questions. So to those of you who attended today, thanks for coming. Please make sure you're a member of the administrative law section in AALS. Again, I won't inundate you with emails, but I will be looking to come up with a topic for next year's conference on the soon side. And I'd really like to get some new voices in here, perhaps some people outside our tight cadre of administrative law folks, more junior scholars would be terrific also. So please become a member of the section and look out for the email with additional questions that we didn't get to in the panel today. And thanks so much for the three of you for joining us for what I think has been a really interesting discussion. And hope to see you all. I believe that John Choi has a workshop on his paper going right now. Brian Camp can send you the Zoom info for that. We have our New Voices program starting this afternoon. Please look out for the emails on that and get, in case the breakout rooms don't work, each of the authors has arranged a breakout Zoom. So email the authors directly for those Zoom links, and see you all at Jack Bierman's social hour. Thanks a lot for coming, everybody. Hopefully see you in person next time.